tonight is Amy Goodman, one of the real heroes of the independent media. She is the host and executive producer of Democracy Now!, a national, daily, independent, award-winning news program, airing on over 400 public radio and TV stations in North America. She's an investigative journalist who has reported from East Timor, Nigeria, Mexico, Haiti, Cuba, and recently from Doha and London. And she is the co-author with her brother, journalist David Goodman, of the New York Times bestseller, The Exception to the Rulers, exposing oily politicians, war profiteers, and the media that love them. You can find out more about her show and sign up for the Democracy Now! Daily Digest at the website democracynow.org. Ladies and gentlemen, Amy Goodman.
Spying, torture, war. Tonight we're going to talk about an issue that is not raised very much in the corporate media, because the range of debate there is largely between the Democrats and Republicans in Washington, and all too often they agree. We need a media that opens up the spectrum to hear a vast array of opinions. And whether you agree or disagree with what is being proposed here tonight, I think it's very important that we hear these alternative points of view, because they very well may not be those of just a fringe minority or even a silent majority, but the silenced majority, silenced by the corporate media. The first paragraph of this new book, Articles of Impeachment Against George W. Bush, reads, "How can it be that we're yet again debating another presidential impeachment, still weary from the Clinton impeachment battles, and now completely exhausted from the momentous changes brought about by both 9/11 and this president, changes that include the Iraq War, indefinite detentions around the world, torture, domestic wiretapping, and more. We have all we can do to understand and perhaps resist some or all of these measures on an ad hoc basis. While any of the individual acts and policies outlined in the following articles would constitute an impeachable offense, taken as a whole, as a pattern in practice, they constitute something far more sinister, a plan to significantly weaken, if not destroy, our democracy." That is what is put forward by the Center for Constitutional Rights. You can decide by the end of the evening if you haven't already. Each of the lawyers for the Center for Constitutional Rights will take on a specific issue. Then we'll have a discussion, and then we urge you to write down your questions, and we will present those to the lawyers. We're going to begin with Bill Goodman. He is the legal director at the Center for Constitutional Rights. He's led a team of attorneys challenging the Bush administration since 9/11. Landmark cases include Rasul versus Bush, representing the Guantanamo detainees before the Supreme Court, Arar versus Ashcroft, and you'll learn about who Maher Arar is, the first case to challenge the extraordinary rendition or outsourcing torture, plus a class action on behalf of Muslim and Arab men caught up in the post-9/11 immigration dragnet. The first case to succeed in having a portion of the Patriot Act ruled unconstitutional. He leads a group of attorneys in a suit under Germany's universal jurisdiction law, charging Secretary of Defense Donald Rumsfeld, the Attorney General Alberto Gonzales, and other high-ranking officials with war crimes. Bill also supervises an extensive corporate accountability and international human rights docket, a racial and economic justice docket, and a wide array of government misconduct cases. He was responsible for the racial profiling case against the New York Police Department that led to the dismantling of the notorious street crimes unit that was responsible for the killing of Amadou Diallo. Bill Goodman.
Thank you, Amy, and good evening, everybody. It's a pleasure to be here with you and to work with you this evening to try to draw out a discussion on why impeachment is on the agenda and an appropriate issue for discussion amongst all of us and amongst those people whom we have elected to Congress. As Amy said, immediately after 9/11, we at the Center for Constitutional Rights began to receive telephone calls that were inquiring and seeking to find out where our brother is, where our father is, where our son has been taken. These were not calls from Iraq or calls from the West Bank. These were calls from Brooklyn and Staten Island and elsewhere in the United States. And these were calls about men who were our neighbors and lived amongst us and people who lived next door to us. And what happened after 9/11 was that the Bush administration began to take people who they claimed had overstayed their visas, and in many cases they had, men who had been working without appropriate green cards or papers that allowed them to work, and in many cases they had. And instead of processing these people as they had for years in the United States and bringing them in front of an immigration officer and dealing with the issue and sometimes deporting them, they took these men and held them in maximum security locations in places like Brooklyn, New York, in the Metropolitan Detention Center. And not only did they take a random group of people, these people were all Muslims, almost all, and in the one case, one or two cases where they were not, they were believed to be Muslims by the Immigration Service and the FBI. They were all either from the Middle East, mostly Arabs from the Middle East, or from South Asia. And they were all held for extremely long periods of time. I personally went and visited and talked to many of them and got to know many of them. And after they had been interrogated by the FBI and after they had had an immigration hearing and after they had been ordered deported, they were held and held and held and held. And people, when we began to ask why hasn't anybody brought these people in front of a judge for a hearing, why hasn't anybody been charged with a crime, they're all being held as for some purpose of criminal investigation. This never happened, and they were deported. And it became obvious to us because we would hear stories as to each one of them. I heard this over and over again, that when they entered the MDC, somebody's head would be taken and smashed against a wall, and they would be told, this is for 9/11, welcome to the Metropolitan Detention Center. This happened repeatedly. So this one pattern, it became clear, was being directed from Washington, was well known to the FBI, was well known to John Ashcroft, the Attorney General of the United States, and it was obvious that this was an administration that was hell-bent on undermining the Constitution. It was based off of that experience and then Guantanamo, which came to our attention, and one after another, that it became clear that this was a president who was bound and determined to find ways to avoid living up to his responsibilities under the Constitution, to avoid oversight from the judicial branch of government, and to no longer do what he had been told to do by Congress in certain instances. And as I said, I mentioned Guantanamo. I certainly mentioned the original detentions. None of us, everyone in this room is aware of how we were lied into war in Iraq. And then recently, and in another example, it became obvious to us, because it was reported in the New York Times, that this administration was engaged in massive and widespread wiretapping without going to judges and getting warrants. Even FISA court judges, it's a very compliant court, but Congress had said that the only way you can engage in certain kinds of international electronic interceptions is by going to this FISA court and getting a warrant. This is the exclusive manner to do it, according to Congress. Shane is going to talk about this. And if you don't do it, it violates the law. It's a crime. So one after another, the Center for Constitutional Rights has engaged in litigation, has hoped for some final resolution from the courts. From time to time, we've gotten answers, and we've had to go back and continue to fight as if we had not won. For example, in the famous Rasul versus Bush case, which has to do with illegal detentions without habeas corpus at Guantanamo Bay, Cuba. And so when Dennis came to us and said, "We want you to write a book about impeachment," and I said, what do you want us to say about impeachment? He said, "Just describe your cases." That's why I said, yes, that's something we can do. We talk about our cases all the time. Our caseload is not the only basis for impeachment, but it constitutes a large part of it. And what it describes is abuse of power and misuse of power and an attempt to undermine the basic architecture of our democracy, which is a system of separation of powers and checks and balances. Now, to many of us today sitting in this room and watching on television, when I say the word George Mason, people are going to think about a three-pointer. We are not talking, however, tonight about George Mason, the Cinderella team in the NCAA playoffs. What we are talking about is one of the framers of the Constitution of the United States, who originally talked about, originally it was proposed that the basis for impeachment should be bribery or treason. Mason said, let's open this up a little bit. The people and the people's house need to have an outlet to deal with abuse of power. These are people who had just been through the Revolutionary War in the United States. That war was fought over the issue of abuse of executive power by another George 300 years ago. And today, or at that time, George Mason said, what we should talk about is maladministration. Well, some people said, no, then it'll just become a political tool. They'll use it for every little folly that may come up. Suppose the president has an affair and lies about it, for example. And you know, we don't want it to be used for trivial matters. And so they changed that to high crimes and misdemeanors, by which it was meant at the time, and it's clear in the original, through reading the history of this period, that what they were talking about may not have been merely maladministration, but it was abuse and, more importantly, misuse of official power. This is what the remedy of impeachment is geared at and gauged for. And today, believe me, speaking as lawyers and speaking on behalf of the Center for Constitutional Rights, we look for rectification and a declaration of what our rights are and how they have been transgressed by this administration from the courts. We seek it, we actively court it, we argue, we brief it constantly in courts. However, there are other remedies, and part of that has to do with the remedy of impeachment. This is a people's remedy. And people may say, well, it's in Congress, it's controlled politically, you'll never get there, and all of that. But I'm here to tell you tonight that all over the United States, in towns and villages and community meetings from California to New England, this issue is being debated, and local councils are voting on it, and it is the basis for a groundswell which I think will continue to develop. So based upon that consideration, I turn the rest of the meeting over to Amy and the other lawyers from the Center for Constitutional Rights, who will describe in detail our caseload and why, taken either as an individual matter or collectively, this caseload and other issues constitute a valid basis for impeachment. Thank you very much.
Shana Kadidal is going to address the issue of spying and the National Security Agency. He's a staff attorney at the Center for Constitutional Rights here in New York City, a graduate of Yale Law School and a former law clerk to Judge Kermit Lippes of the United States Court of Appeals for the First Circuit. He's worked on a number of significant cases since 9/11, including the center's challenge to the detention of prisoners at Guantanamo. He has filed center's amicus briefs in the cases of 2 citizens detained as enemy combatants, several cases on behalf of immigrants challenging the government's policy of closing their deportation hearings to their families, the press, and the public, and a case on behalf of a class of hundreds of immigrants held in immigration detention long after their final deportation orders, solely in order to allow law enforcement to conduct criminal investigations without probable cause. He is also counsel in the center's pending challenge to the NSA's warrantless surveillance program, CCR versus Bush. Shana.
Well, thanks, Amy. Well, I'm going to talk about the first article of impeachment that we propose in this book, which is directed solely at the warrantless wiretapping that was disclosed by the New York Times and then admitted to by the president in the middle of December last year. As Amy said, we filed a case on January 17th challenging this practice, asking the court to order that it ends. And, when I talk about this case, I like to say that usually when you start a case up, you know more about the facts than about the law. You've talked to your client, you know what happened, you're not quite sure where the court is going to come out on the legal standards that apply. Here it's exactly the opposite. We know that unquestionably that what happened here was criminal and that it was illegal. The Foreign Intelligence Surveillance Act says expressly that it and the Wiretap Act of 1968 are the exclusive means by which the president can conduct electronic surveillance like wiretapping. So we know absolutely clearly that what happened here was illegal. The big mystery is not whether it was legal or not, but rather why they did it and who they were spying on. Now, why are we concerned with who they were spying on? Well, I think that's probably obvious because the program, it's been alleged, has been targeted at communications of persons in the United States with people outside of the United States who have some link to terrorism. And the administration asserts that pretty much all of our clients in our post-9/11 litigation are people outside of the United States who have some link to terrorism, including the folks that Bill was talking about who are all deported to their home countries. So the fact that the administration might be spying on us, has a deleterious effect on our litigation. It means that, for instance, prospective clients and challenges that we might bring, challenging this administration's other illegal conduct in its war on terror, those clients might be reluctant to bring litigation if we have to disclose to them in our first conversations with them that, look, you've got to be careful about what you tell us over the phone or what you email us because the government may be listening over our shoulders. It makes us look suspect. It may make the clients not want to go forward and challenge this administration's illegal conduct in court. So that's why the question of who they're spying on is particularly important to us as civil rights lawyers. But the question of motive, of why they chose to do things do this electronic surveillance without getting wiretap warrants from any court, that's an important question to the impeachment question. If you remember, the second article of impeachment against Richard Nixon was directed at his wiretapping of anti-war protesters, civil rights movement leaders, and so forth, basically all his political opponents, that was carried out for purposes unrelated to national security. It was basically carried out for the political benefit of Richard Nixon himself. Now that's kind of the shining example of wiretapping, warrantless wiretapping that is an impeachable offense, where it's clearly something that was done for the two sort of purposes that we usually look to define an impeachable offense, that it's something that subverts the constitutional structure of government or sort of undermines democracy. So Richard Nixon was spying on his political opponents to get dirt that he could use against them to weaken their political challenge to him and make it more likely that he would be reelected. And he was going around the court system to do this. He didn't want judicial review because there wouldn't have been any grounds to justify those warrants. And that's why he was sort of attempting to subvert the three-part structure of our government and the judiciary's role in reviewing these wiretaps. Well, we don't really know a whole lot about the motives that the administration had for this program yet, because a lot of the facts really haven't come out. So I thought I would talk a little bit about what we do know, and then speculate a little bit about what the motives might have been. As I said, the program is allegedly directed at only international calls and emails. That is, communications that are coming from someone outside the United States to someone inside the United States, or vice versa. The interceptions appear to be taking place in the United States, which would put them, sort sort of clearly under the umbrella of the Foreign Intelligence Surveillance Act, meaning that they're regulated, that all such interceptions that happen in the U.S. are supposed to go through a court, and I'll talk a little bit about that process later. But the important thing is that they clearly come under FISA, and the administration's eavesdropping here is warrantless, which means that they never go to a court for approval beforehand for these wiretaps. Now, Attorney General Gonzalez has said that these wiretaps are targeted at people who have some link to terrorism, either al-Qaeda or affiliated groups. But the media reports on this program have alleged something much broader, that it's more like a data mining program, which means essentially that the government might be using computers to scan the contents of every single email that goes in and out of the United States, and perhaps use voice recognition technology to maybe pick up, the presence of a single word in every single phone call that goes in or out of the United States. I mean, we're unclear as to whether or not this is genuinely within the technological capacity of the government at this point, but the newspaper reports have indicated that something like this is what's going on, although the administration has denied it vehemently. I thought I'd talk a little bit about the sort of ordinary process for instituting wiretaps. Again, there are two statutes that govern this, the Basic Wiretap Act for domestic wiretaps and the Foreign Intelligence Surveillance Act that governs sort of intelligence gathering that may be directed at foreign powers or agents of foreign powers. There's two things that these statutes both have in common. One is that law enforcement has to come to a judge before it institutes a wiretap, for the most part, with some evidence that indicates that the person being wiretapped is a worthy target to be wiretapped. Then the judge is supposed to review it and make sure that it meets that appropriate level, that the executive isn't just making this up. And then the judge is supposed to issue a warrant, which kind of puts limits on the scope of the search. So if it's a physical search, the judge might say you can search these rooms, but not their whole house, not the person's office, or things like that. For wiretaps, it's usually something that limits the length of time or limits the sort of phone lines that can be tapped, that sort of thing. But the idea is that a judge is supposed to review the process and put sort of a tight limitation on the discretion of the executive to carry out this kind of intrusive search. The standard is usually probable cause, which means for a domestic wiretap, you've got to show some evidence of criminal activity. For a Foreign Intelligence Surveillance Act wiretap, you've got to show some evidence that somebody is linked to a foreign power. There are two reasons we ask for that kind of standard. One is to protect innocent people from being searched or surveilled in this way, but the other reason is to make sure that law enforcement kind of focuses on threats that are real, that it doesn't sort of go around willy-nilly searching everyone and anyone based on its prejudices or doing sort of broad profiling of the general public. I'll say a little bit about FISA. FISA was set up by Congress, passed in 1978, in kind of the wake of the Watergate scandal and the revelations about Nixon's wiretapping. But it was really a very middle-of-the-road statute. It wasn't, sort of an extreme overreaction. About half of Congress really thought that the president ought to have more or less unlimited power to gather information about foreign powers and their agents in the U.S. And Congress thought very deeply about wartime situations. So FISA contains two provisions that are kind of relevant here. One of them allows the president in emergency situations to put a wiretap in place and then go to the court for approval of it within 72 hours. So FISA allows for basically retroactive approval of wiretaps that have already been put in place. And then when Congress has declared war, FISA allows the president 15 days of kind of carte blanche. And the idea wasn't that of wiretapping without ever going to the FISA court. And the idea wasn't that war is a special situation and the president should have complete freedom in war. The idea was that 15 days was long enough to pass another statute. So that if a certain wartime situation emerged that created new exigencies, a real sort of crazy emergency situation, well, Congress could respond to that by writing a new statute. But the idea behind the structure of the entire FISA statute was that the president was always going to be limited in some way by Congress, by something written in a statute in terms of his ability to carry out wiretaps. Now, the FISA court, as Bill mentioned, is very, very friendly to the administration. Out of the last 18,800 applications that have been made to it, only 5 have been rejected. So that immediately, really astonishing, immediately brings up the question of motive here. Why did the administration choose to go around a process that provides for retroactive warrants, that provides for, that contemplates the wartime situation, and where the court has been incredibly friendly to the administration? Well, they've offered a few defenses, but most of them are weak. The first one that the president offered was that the process was too slow. But obviously, there's nothing faster than a retroactive warrant. So that one really doesn't hold much water. The second one is that basically that they feel that Congress had already authorized this when it gave the president approval to use military force in Afghanistan. And that one really is a little disingenuous. I mean, Alberto Gonzales, in his first press briefing on this NSA surveillance program, said that they had thought about going to Congress for approval of the program explicitly, but they were told that Congress wouldn't approve it. So it's a little disingenuous for them to say, well, they gave us implicit approval when they said you could go after Osama in Afghanistan, but they never would have given us explicit approval. Doesn't really hold water either. And then the third one, which I'll mention, that the president mentioned during his State of the Union address, is really probably the most bitterly ironic. It's that maybe we would have caught the 9/11 hijackers if this kind of warrantless surveillance had been in place. And, it's bitterly ironic because he's talking about a program run by the NSA, and the NSA, in fact, knew that the two San Diego hijackers, Khalid al-Mihdhar and Nawaf al-Hamzi, were present in San Diego because the NSA had a lawful wiretap under FISA on a safe house in Yemen. So they knew they were here, but the reason they didn't communicate it fully to the FBI or CIA was because they didn't appreciate the significance of these two individuals. The FBI and CIA had information that they in turn hadn't shared with the NSA to show them, that these guys were significant. So really, you've got a failure of the intelligence sharing rather than the fact that the wiretapping statutes might have been too strict. So given that all these, sort of defenses that the administration has offered don't really hold much water, well, what are the possible motivations? I think there are three that we've speculated might be behind this program. One is just sort of a general program to aggrandize the executive. Dick Cheney's gone around saying that there was an erosion of presidential power in the wake of the Watergate scandal, and that this is something that's weakened our country and it should be reversed now. So it may be just on the president's general agenda to do things that indicate that he doesn't need to seek review from courts, and that he doesn't need to listen to Congress when it passes a statute that limits his powers in the national defense sort of area. And so that's something that potentially is subversive of the structure of government and could conceivably be an impeachable offense if that's their motive for doing this. The second one is a little bit more sinister. If the program is in fact not targeted just at people who have a specific link to terrorism, but in fact it's something more like that data mining program that I talked about, that it's so far afield from the Fourth Amendment's requirements that a warrant be sort of specific and that it limit the nature of a search, that it could never pass muster before any court. And moreover, it would be something very similar to sort of John Poindexter's Total Information Awareness program, which is the same sort of thing, and something that the American public found really creepy, and that Congress decided that it was going to specifically withdraw funding for. So the president would have been ignoring the will of Congress and also, the obvious sort of will of the American people, and carrying out something that was so akin to a general warrant, the kind of thing that the colonists found so abusive when King George did it, that I think that could also clearly be an impeachable offense. And then finally, I think the third possible motivation is that it may just go to the targets of this particular type of surveillance. If the administration was trying to listen in on the phone calls of journalists with their sources, or of attorneys, civil rights attorneys in particular, with their clients or with witnesses in their cases overseas, or other human rights lawyers overseas working on these cases, well, that's the sort of thing that even a very conservative FISA court judge might not approve of, even given the record of the FISA court and sort of being so accommodating to the administration. And if that, in fact, was the motive for going around the very friendly FISA procedure to do this sort of surveillance in this way, well, then that also is clearly an impeachable offense. It's very similar to the sort of thing that Nixon was doing, especially when you consider how difficult it makes it for us as civil rights attorneys to challenge the other illegal and unconstitutional conduct of this administration in its war on terror. I'll just mention a few other things. Last Friday, the administration issued some responses to questions from the Democrats in Congress, and one of the questions was, have attorneys' communications with their clients been eavesdropped upon? And the administration, in most of the other 40 questions that were submitted, said we can't answer that. It would divulge too much about the program, divulge sort of sensitive classified information. On this question, they said we can't rule that out. So they're basically admitting, I think, that our third speculative motive, that is that they wanted to be able to spy on attorney-client communications, and that maybe the FISA court wouldn't have allowed it, that might actually have been what was happening here. One of the, we're in a situation, I think, where litigation may not necessarily result in more information coming out about the facts, and therefore more clarity coming out about the president's motives. But one, I think, important service of impeachment proceedings, of hearings before Congress on all this, is that it may actually help some of those facts come out at the end of the day, as may criminal indictments, because FISA makes all of this sort of surveillance outside of its boundaries a felony. And so the president, if he used or disclosed this sort of information, or any number of his underlings, may have committed felonies. And, just as many criminal indictments helped get the facts about Watergate out, especially when John Dean and others pled guilty, that could be the situation that we see here. It's not entirely unrealistic.
Michael Ratner will talk about war. We'll talk about the invasion and occupation of Iraq. He's the president of the Center for Constitutional Rights, has been deeply involved in defending civil liberties in the United States post and pre 9/11, co-counsel representing Guantanamo detainees in the Supreme Court, where a major victory was won in June 2004, and his office has sued two of the private contractors in Iraq, alleging their employees were involved in the abuses and torture at Abu Ghraib. On the issue of Guantanamo, it's not the first time Michael's been involved with Guantanamo. He was involved, acted as a principal counsel in the successful suit to close Guantanamo for HIV-positive Haitian refugees years ago at the time of the coup against President Aristide, and has acted as special counsel to Haitian President Jean-Bertrand Aristide to assist in the prosecution of human rights crimes. Other cases that he's been involved with include a challenge to the Patriot Act, a lawsuit on behalf of post-9/11 immigration detainees in the U.S. in representation of Maher Arar, which we'll hear Maria LaHood talk about in a little while, the Canadian citizen sent and rendered to Syria. Michael Ratner.
Thank you very much. I really appreciate your all being here, and particularly being here with Amy and my colleagues from the Center for Constitutional Rights. It's been an incredible 4 or 5 years of litigation of what I consider to be, at this point, a government of tyranny and not a democracy any longer. You know, we saw it coming soon after 9/11. I remember writing an article called "Moving Toward a Police State, or Have We Arrived?" And I didn't know anything then compared to what I know now in terms of torture, Guantanamo, national security warrantless wiretapping. There was no war in Iraq at that point. And at this point, even as your former presidential candidate Gore said, he basically used the word tyranny in describing what this government is doing. Unfortunately, it seems that the Democrats do better when they're not running for office when they're in office. Because, you know, one of the important resolutions that has come forward has been the Feingold censure efforts, which there'll be a hearing on Friday. Now, the Center's position on that, of course, is that it's a good thing to start there, but that censure is not enough. Impeachment is necessary. The hearings will be there on Friday, but to see the way the majority of the Democrats have run from that resolution, which is about national security, wiretapping, illegal wiretapping, is extraordinary to me. I mean, when you go to them, it's not even a political question. You just want to say to them, stand up for the Constitution, stand up for the Fourth Amendment. Which reminds me, yesterday in the mail I received this tie, and this isn't like me at all. It's like wearing one of those little American flag pins. It actually happens to have the Constitution written on the tie, which you can't see there. It's a small type. But you could take a scissors really to it and cut out the First Amendment. You all know that one. That's, you know, right to free speech, protest, be free from surveillance to a certain extent. Fourth Amendment, right to be free from searches, right to be free from electronic surveillance without a warrant. Fifth Amendment, right to due process. What's happening in Guantanamo and in other CIA hellholes around the world is certainly not due process. Sixth Amendment, right to an attorney, and as Shane said, we're actually seeing attorneys conversations. We believe many of our conversations from the Center have been overheard as we talk to our clients and their families all over the world. The Ninth Amendment, right to privacy. The Eighth Amendment I left out, the right to be free from cruel and unusual treatment. So you're talking about really an utter cutting up and chopping up of my poor little tie. But what's left in there is the impeachment clauses, and hasn't been able to get rid of those. And the two standards in there, the president really takes two sorts of oaths. Really, one's an oath and one's an obligation. One is an obligation to preserve and protect the Constitution of the United States. And that's what they usually, when they're talking about an article of impeachment, that's the one they mention a lot, along with the one to faithfully execute the laws. And what the first one means, protect and preserve the Constitution, we have a constitutional system of checks and balances in this country. The president has limited power. The Congress makes the laws. The Supreme Court ultimately is the arbiter of what those laws mean, and the president is to faithfully execute those laws. What's really happened, and you'll hear it from each of us on the panel, is the president has taken on all three of those functions. He's done it whether it's with regard to torture or with regard to warrantless wiretapping or Guantanamo or a number of other issues. And that's when we're really talking about a police state and tyranny, and that's really when we're talking about executive tyranny is the best word I could use. Clearly impeachable. Clearly, at a minimum, we should be in full-scale hearings, really, in the House of Representatives, which is, as you probably know, we didn't say, but the House of Representatives votes articles of impeachment. After they're voted on, they come out of the House and they go to the Senate, where there's a trial on those articles of impeachment. And at that point, if the person is convicted, and no president has actually ever been convicted in the Senate of impeachment. As you know, Nixon resigned prior to even getting the articles out of the committee in the House. In any case, that's the broad way I look at it. I was asked to talk about the war in Iraq, and I remember when Dennis, who asked me to write that chapter of the book, came to me and said, write about the war in Iraq, and I said, well, you know, I could do the torture chapter more easily. That I have to really do some work on and look at stuff. And I started to read through things that you've heard of, the Downing Street memo, and go through a lot of the material on the war in Iraq. And I was, even for someone like me who follows the news very carefully, I was utterly shocked by, you could compare a presidential statement saying that today, for example, Iraq is buying yellow cake uranium from Africa, or today they're buying uranium tubes, or there was a meeting in Czechoslovakia between an Iraq intelligence agent and Al-Qaeda and Mohammed Atta, one of the hijackers. Each day that they said that, each day the administration made such statements, they knew at the very time they were saying that information was false. You can go through scores of them, and in fact, one of the members of Congress went through and found 250-some false statements in 125 public appearances. This was from the beginning till the end. And I was really flabbergasted by it. And in the book, I lay out some of that. Some of it you all know. If we want to talk about why going to war with Iraq is impeachable, there's really two sorts of theories. One is that the war was just flatly illegal, apart from the line. It was flatly illegal even for Congress to vote for it, in the sense that the United Nations had not agreed to that war. And there's only two ways, really, after the Second World War, that you can go to war against another country. One is in self-defense, if you're attacked, or if you're about to be attacked, which is where they try and bring in this little preemptive thing, but we weren't about to be attacked, that's obvious. So one is self-defense, and the other is if the United Nations Security Council gives you authority. Obviously, we weren't about to be attacked, nor did the UN Security Council give us the authority. So it's clearly a violation of the UN Charter. It's a treaty of the United States. It's a violation of the Constitution, which makes the UN Charter the supreme law of the United States. It's a subversion of the law. It's a clear, as I said, not only an illegality, but a violation of the Constitution. The second reason for impeachment for the war is the one that really people focus on more. And the one that people focus on more has to do with the series of lies that were told to the American people and to the Congress about the war. And you can begin going in, you can trace the history back to the whole doctrine of preemptive strike in Iraq, which took place prior to 2001, where already the same guys who eventually took power in the administration, Rumsfeld and company, were already talking about Iraq, were talking about preemptive strike, and once 9/11 happened, they saw it as their opportunity. As one of the documents had said earlier, they saw 9/11 as what you might call their Pearl Harbor, their way of finding a justification for going to war against Iraq. And that's the way they used 9/11. Clearly, it's clear if you go through all the evidence of it. And it was based on two primary pillars, both of which proved to be utterly false. One of them is that Iraq had weapons of mass destruction. And that, as I said, you know some of the stories about, particularly the one about the uranium, the tubes for spinning, the aluminum tubes for refining uranium, the other one about yellow cakes, and then there were ones about mobile biological weapons labs that were moving around. All of those stories were false, and they were not just false later, they were false at the time the administration was giving speeches about it. So that in January 2003, when Bush is giving a speech, a State of the Union about Iraq, he is still talking about weapons of mass destruction and quoting British intelligence about the uranium tubes, knowing full well that it was utterly and completely false. So the American people were lied to, and Congress was lied to as well about weapons of mass destruction. So you see one pillar just demolished. You know it. The evidence is very, very clear there. The second pillar, of course, is whether Iraq had anything to do with 9/11. The one incident they always bring up is the one I mentioned earlier, the so-called meeting of Muhammad Atta in Czechoslovakia in 2001 with the Iraqi intelligence member or diplomat. Apparently it never happened. And despite it never happening, the administration kept referring to it. And even when they stopped referring to it, they still always, if you look at any of the Bush speeches, the Cheney speeches, or other of the administration officials, they always talk about Iraq and 9/11 within the same paragraph, within the same two paragraphs, even though they never actually, as it later turned out, were able to prove any link at all. And they knew it, but they kept when they knew it. They couldn't any longer lie at the end, so they just said, well, because it was too obvious, they just said, well, 9/11, we have to protect ourselves from the next terrorists, and we have to go after Iraq. So those are the two pillars of the Iraq War. They were both based on not just a tissue of lies, but really pile of lie after lie after lie. And then, of course, you know, finally, I think you all saw 2 days ago, the New York Times decided to talk about one of the Downing Street memos. The Downing Street memos, as you know, are memos that came out of the British government. They were summaries of conversations that various members of the British government had with Bush and with other people within the administration. And the first Downing Street memo came out quite a while ago. That's the one that has the famous line, they're going to go to war essentially no matter what. I'm paraphrasing. This is speaking about the U.S. And they want to fix the facts and the intelligence around the policy. What that means is they want to make sure that they'll manipulate all of the facts to make the case for war strong along those two pillars that I talked about, weapons of mass destruction and the link with 9/11. So that memo is extremely damaging. It demonstrates that what they were going to do was manipulate the facts to justify the war. And of course, that's what they did. They did it in the ways I've told you. They did it by setting up a separate intelligence unit under Rumsfeld in the Pentagon that only looked at certain facts and then wrote memos based on those facts as a way of justifying the war. The second Downing Street memo, again, was out there in the public domain 8 months ago. These were written in 2002 and 2003. Out there 8 months ago, finally the Times wrote a big story on it a couple of days ago. That memo really should just give shock. It should just shock people, but for some reason the article sits there and nothing happens. This is the one where Bush apparently said we should take a U-2 plane of the United States and fly it over Iraq and paint the United Nations colors on it, paint the UN colors on the plane so that when Iraq, and try and tempt Iraq into firing on the plane as a way of provoking an incident that would lead to war. This was in 2003, just 2 months before the beginning of the March War, when they still are looking at a provocation because they still don't have the authority of the United Nations. So they say, we're going to paint this airplane and we'll do it. We don't know whether they did or they didn't, to be honest with you. We know they never used it as an incident that they needed because in the end they couldn't find enough and they had to go to war without the UN authority. That was one of the things it said in the memo. It also said they would try and get an Iraqi defector to talk about weapons of mass destruction. That, of course, they were somewhat successful on. They got a number of Iraqi defectors to talk about WMDs, and they were all lies, lie after lie after lie. So there you see these two memos, which are really, if you need a smoking gun on, this was an illegal war, this was a war based on utterly false information, this was a war in which the American people who have a right to decide about going to war, and our Congress people have a right to decide, were utterly and completely lied to. There's more that I could talk about that, but it just, when I read and prepared that chapter, I can tell you, as I said, I was just utterly shocked by it. another one, an incident that got me, uranium tubes. One day, a Sunday, Judith Miller writes the story about the uranium tubes in the New York Times. Aluminum tubes, I'm sorry, that were there for refining uranium. And on that same day, 5 administration officials go on the air on every major network to talk about the aluminum tubes. Coordinated effort at what was known to be false at the time. So, do I think this man is impeachable? I mean, come on, guys. This is extremely serious. Not only the stuff that Shane is talking about, which is clear, it's the type of stuff that got Nixon on, but the stuff that Maria's going to talk about, the abuses, the torture, that kind of material, and then the third, this Iraq War. Now, a war is difficult. War can be difficult to impeach people on. War can be difficult because we tried to impeach.
You have investments in downtown Brooklyn along with your brother.
Who are you?
Develop, don't destroy Brooklyn says you're invested in that. What about human rights in downtown Brooklyn that you're violating?
Okay. This is not the appropriate.
What about the human rights of people in downtown Brooklyn? Grab your hands off downtown Brooklyn. Grab your hands off downtown. You got money invested in this operation.
Okay, it's not the appropriate forum. Okay, it's not the appropriate forum for discussing the politics of my brother in downtown Brooklyn. So that's
he does agree Bush is a liar.
But what?
He does agree Bush is a liar.
Good. At least that's the case. But in any case, war is very hard to impeach presidents for. You know, they did try and impeach Nixon for bombing Cambodia. Liz Holtzman, to her credit, great credit, put in a resolution to try and impeach Nixon, and it was not voted on as an article of impeachment. So this is a very, very difficult one to get him on, but I have to tell you, it's one of the clearest I've ever seen in my life. And in some ways, John Dean said, John Dean wrote a book called Worse Than Watergate. And he says in the book, look, whatever we did at Watergate, it was bad, of course it was bad. But we didn't go and kill thousands and thousands of people. And when we look at Iraq, and when I read the paper today or yesterday, or all of us do, and we see who's being killed in Iraq on a daily basis, you have to say, this administration has to be impeached. And then I got to tell you, you got to indict him afterwards for war crimes. Thank you.
Maria LaHood is a staff attorney with the Center for Constitutional Rights since 2003, where she specializes in international human rights litigation. She works on corporate accountability cases, including Wiwa versus Royal Dutch Shell for the killing and torture of Ken Saro-Wiwa and other human rights activists in Nigeria, and is also working on the case Corey versus Caterpillar on behalf of Palestinians killed and injured in home demolitions, and Rachel Corey, who was killed on March 16, 2003, 3 days before the invasion of Iraq. She was standing in front of the home of a family of Palestinians trying to prevent the home's demolition. Caterpillar bulldozer crushed her twice and killed her. Maria LaHood recently helped bring 2 class actions against former Israeli officials for war crimes, one for the bombing of a residential neighborhood in Gaza that killed 15 Palestinians, injured more than 150 others. The other for the shelling of a UN compound in southern Lebanon, which killed over 100 civilians and injured hundreds more. She also represents Canadian citizen Maher Arar, which she will talk about tonight in the case against U.S. officials for sending him to Syria, where he was tortured and detained for a year. The first case that challenges extraordinary rendition. Maria represents CCR before the Inter-American Commission on Human Rights on issues of arbitrary detention, torture, and rendition. Maria LaHood.
Thank you, Amy. Thank you. The third article of impeachment against President Bush has to do with his authorization of indefinite detention without due process and with his condoning torture. After 9/11, President Bush declared a so-called war on terror, in which he decided that the laws of war and the Constitution do not apply. The administration has detained thousands of people with no due process, without criminal charges, and most without any access to counsel. After 9/11, the president issued a statement that the Geneva Conventions don't apply to al-Qaeda, and that al-Qaeda and Taliban members do not deserve prisoner of war status. So the administration picked up prisoners from all over the world, not just Afghanistan, but Pakistan, Zambia, Gambia, Bosnia, and sent about 750 of them to Guantanamo, which is probably the best known place where people can identify that there are detainees being held by the Bush administration. He labeled them enemy combatants and said they could be tried by military commissions and subject to the death penalty. Military commissions that don't have to comply with US law nor military law. They've said, the Bush administration has said, these men are the worst of the worst at Guantanamo. A recent study, based on facts gleaned from the Department of Defense's own documents, shows that only 8% of the men at Guantanamo were al-Qaeda fighters. 86% of the prisoners there were picked up for bounties. The US paid somebody, and they were delivered to the US for money. 55% of the people there committed no hostile act, according to the Department of Defense's papers. These are the people we know about in Guantanamo. There are still over 500 men there 4 years later. Not one of them has been subject to a trial. Only 9 of them have even been charged with a crime. This doesn't count the 17,000 men that have been or people who have been detained in Iraq, or the thousands detained in Afghanistan. Nor does it count the people that have been sent to secret prisons, which we don't even know about, we only hear about, all over the world. Places funded and run by the CIA, or at least financially assisted and maybe directed by the CIA. In the places we do know that the government is detaining people all over the world, people are being tortured. Everyone's seen the pictures from Abu Ghraib. There are people being tortured in Guantanamo. There are people being tortured in Afghanistan. Despite the fact that the government says that it doesn't, that the Bush administration specifically says it doesn't condone torture, you have to look at what it does, not what it says. Torture is illegal. It's unconstitutional. It violates the criminal laws in the United States. It violates international laws. It's universally prohibited under every circumstance. There are no exceptions. So what has the Bush administration done in response to torture? First of all, there were actually legal memorandum sanctioning torture that were underneath Bush. So the notorious August 2002 memorandum actually said, this is from Jay Bybee to Alberto Gonzales, it said that it concluded that in order to constitute torture, the pain has to be akin to that accompanying serious physical injury, such as organ failure, impairment of bodily function, or even death. The memo also concluded that even if there is torture, so even if the pain is as bad as death, then you may be able to get around liability because of the president's commander-in-chief power and because of possibly military necessity. So if someone under your command wrote this memo, what would you do? Well, you would not fire him, you would nominate him to be a judge. He is now sitting on the Ninth Circuit Court of Appeals, Jay Bybee. Alberto Gonzales, we all know, was made Bush's Attorney General. This memo later was superseded. 2 years later was superseded, and that memo disagreed with the findings of the previous memo. But the men who created it are now promoted. The other thing that Bush has not done is investigate and prosecute high-level officials. Sure, a few of the grunt soldiers have been prosecuted for torturing people, but this was systematic and widespread. From country to country, people in US custody were being tortured. So why hasn't anyone else been investigated? Now, in addition to the torture of people in US custody, this government the Bush administration has had a practice of sending people to other countries to be tortured. Meher Arar is a Canadian citizen. He was born in Syria, lived there until he was 17, and then moved to Canada and has lived there ever since. Other than the brief time that he was actually living in the United States as a telecommunications engineer. He was coming back from a trip with his family. He had a layover in JFK on his way back to Canada. The U.S. government took him out of line, detained him for 13 days, interfered with his access to counsel, the consulate, the courts, gave him an order, woke him up in the middle of the night, put him in shackles, gave him an order saying, you're deemed a member of al-Qaeda, and we're going to send you to Syria instead of Canada. Put him on a jet plane, took him to Jordan, where he was beaten for 8 hours. He was then taken over into Syria, where he was brutally beaten for a couple of weeks, whipped with electrical cables. He was kept for 10 months in a small, grave-like underground cell, 3 feet by 6 feet by 7 feet. No light, dark, cold, rats, for over 10 months. Then a year later, Syria released him and said, he has no links to al-Qaeda. We just took him because the U.S. asked us to. He's now free in Canada. The Canadian government has also said no links to al-Qaeda that we've found. The U.S. government, instead of either admitting its mistake or doing anything else, has not admitted to anything. Just continues to say, well, he's a member of al-Qaeda. In the court case that the Center for Constitutional Rights brought against the U.S. officials responsible for Maher's what's called an extraordinary rendition, being sent to another country, being abducted and sent to another country to be tortured or interrogated through torture, the government came in and said, actually, the reason we deemed him to be a member of al-Qaeda and the reason we sent him to Syria instead of Canada is a secret. We can't tell you. So that's what the Bush administration is doing. That's how the Bush administration is addressing the issues of detention, the issues of torture, the issues of extraordinary rendition. So whether or not it can be, actually shown to be authorized, because a lot of the presidential findings that we hear about are actually still classified in secret. So we can't say, well, Bush ordered this specifically. With detention, we can. With those that we can't, we can say, well, here's what Bush did. He did not punish anyone. He promoted them. He did not investigate. He hid, in fact, any evidence that could have shed any light on it. So for those reasons, Bush should be impeached. Thank you.
We're going to be taking your questions. If you want to put them on cards, they'll be collected, and we'll ask the panelists those questions. But I wanted to ask about 3 things in the news this week and how it bears on your argument for impeachment. One of them, the case that is heard by the Supreme Court today, the case of Hamdan, the Zacharias Moussaoui case the defense has rested today, and what has happened, the developments in that. And also the latest news, you sued the government along with the ACLU to get the pictures of the abuse at Abu Ghraib. And apparently the government has now lost the case and is releasing these images to you and the ACLU. So who would like to take on the case of Hamdan?
Go ahead.
I could just address one part of it briefly. One issue that's being addressed by the Supreme Court, just to back up a step, I guess. The Bush administration, as I think we're aware, the Center for Constitutional Rights won the Roswell v. Bush case, which said that the courts, the U.S. courts, have jurisdiction over the detentions at Guantanamo, over those detainees. And this was in response to the habeas petitions brought on behalf of detainees by the center. So this was June of 2004 that this decision was made. After that, the Bush administration said, well, there may be jurisdiction, but they have no rights to be enforced. So when it started to look like maybe that argument wasn't going to fly, the Detainee Treatment Act passed, in which there's an effort to completely eliminate the rights of the detainees at Guantanamo to bring habeas petitions to challenge their detentions. So the Bush administration now argues that that act, which was passed in December of 2005, is retroactive, and all of the petitions that have been brought and coordinated by the center should be thrown out of court. So one of the issues being decided in Hamdan is that issue.
And I would add that what's happening is that the Bush administration is taking the position in arguing this that people who are being held in Guantanamo, who are being tried and sometimes tried for capital offenses for which they can be executed, essentially have no rights that any court can supervise. So this is, again, as Michael said, executive tyranny. This is the imperial presidency. This is a president who can hold people, charge people, try people, convict people, execute people by himself through his own minions without any judicial oversight, and it is basically anathema to the constitutional law and separation of powers, and the scope of Hamdan, which is just the beginning, is what we fear is that this is what we will all face at some point, that the courts will be so marginalized that we will all be functioning at the whim and will of a single executive, and one who is not that congenial to start with. So this is that's I think what's at stake in Hamdan. On the release of the photographs, Amy, I just want to say it wasn't because we had won that case, although we hope that we have won major parts of it. But Salon magazine, so the internet magazine, published all the photographs, and so that basically once they were all out there, essentially in the internet, the government, I think, has basically thrown in the towel and is not fighting it anymore. I believe that's what has happened in that case.
And the significance of the Zachariah Moussaoui case. What happened with the prosecution, with the judge finding misconduct with the prosecution?
Right. Well, I think people have read about Moussaoui was the so-called 20th hijacker who they had picked up before 9/11, although they have more than one supposed 20th hijacker. We have one in Guantanamo, supposedly. But he's facing, he pled guilty and he's facing the death penalty, and the question on the death penalty is whether or not any of the information that he had he given proper or not lied to the government, according to the government, they could have been able to prevent 9/11 and saved lives. So the question at his death penalty trial is whether, had the government gotten that information, whether lives could have been saved. And a number of government witnesses testified, and they were cross-examined, and they were cross-examined very severely by Moussaoui's defense attorney, and very well, and the government wasn't clear that they could win the case, that they could prove that the information would have actually helped save lives, or that they weren't doing those things anyway. And so what the government did, what one government attorney did, was went to the witnesses that were coming up as the trial went on, and not only showed them the testimony of the witnesses who testified, and these are witnesses who've been excluded from the courtroom, so they're now reading the testimony of other witnesses, but also coached them in their answer to ensure that Moussaoui would get the death penalty. The judge, as you saw in one day in the paper, really hit the ceiling. In the end, she didn't allow those people to testify, but the government brought in other witnesses to testify. But what, to me, the significance of the case is the extent to which the government will go to subvert the law to get convictions. And we've seen it across the country in a number of the terrorism cases, from here in New York to the Lynn Stewart case, to the case out in Portland, where they had a fingerprint that they claimed was a fingerprint of the person who planted the bomb on the Madrid train, when in fact they misread the fingerprint, and even after they were told it was the wrong fingerprint, they insisted it was the right fingerprint. And that's so it's a pattern of subversion of law that is really going on across the country in these so-called terrorism cases.
But I think we should add that what we see here is that at least there is some oversight, there's some supervision, and the court is prepared to step in and say, look, government, you have misbehaved, and we're going to do something to correct it. It may or may not be enough. When these hearings and these tribunals or kangaroo trials are held behind closed doors, and where there's total secrecy and where we don't know what's going on, which is, of course, Guantanamo and many other situations, that's when there is real room and realm for misbehavior and misconduct. And that's the importance of a judicial branch of government, which is what the Bush administration is attempting to eliminate and diminish and weaken.
An important point on the diminishment of the of the judiciary. I mean, one of them is the one Maria mentioned, which is the Detainee Treatment Act, which unfortunately our Congress went along with in terms of stripping the courts of the right to hear Guantanamo cases. But the second one, and you've read about this, I think, also, is what the president does in so-called signing statements and what he did to the McCain Amendment. The McCain Amendment, as you recall, prohibits cruel and inhuman and degrading treatment, which is a form of torture. And it was passed by both houses and signed by the president. The president then added what's called a signing statement, which is his interpretation of what the law means. Very rarely used in the past. This president has used it apparently 500 times to give his interpretations. Now, what the signing statement does, if you had any question about the direction of the country, or the direction of the presidency, I should say, it's open and notorious, and you can't say you didn't know. What he says is, and remember, this is a statute to outlaw torture, cruel and inhuman and degrading treatment. And he says, look, he really, and I'm paraphrasing, whatever the Congress says as far as the prohibition, I have the right to do what I need to do to protect national security. In other words, I can torture people even if Congress says I can't. And then he goes on to say, the courts are limited in this country. I have the right to decide what the law is. I'm paraphrasing again, but that's essentially what he says. So he has the right to ignore a prohibition of Congress prohibiting torture, and a right to ignore what a court decision is if it prohibits torture or similar kinds of things as well. So if you're talking about what he calls a unitary presidency, which is a presidency above all, that's what we have.
Yeah, and something very similar to the Detainee Treatment Act is actually happening right now in Congress. There's a bill proposed by Senator Mike DeWine and another one proposed by Arlen Specter that would basically legalize the NSA program. You know, I mean, it's, as the New York Times said, it's as if, you know, the president admits he's breaking the law, and Congress's response is to pass a statute allowing it to watch and call that oversight. Among other things, the DeWine bill has criminal penalties of 15 years for any government official who discloses any surveillance similar to the NSA program. So really, you know, sort of a kill the messenger kind of program. Just in terms of Moussaoui, one interesting thing is that the FBI might have been able to discover the 9/11 plot if they had gotten a FISA warrant to search the hard drive on his computer. And the local agents who were handling his case wanted to do that. They were overruled by the, you know, sort of, you know, little bloated bureaucracy of the FBI and its central office. Yet, when the 9/11 Commission was taking place, a number of government officials said, look, you know, the FISA statute is too strict, and that's why we couldn't get that FISA warrant to look at Moussaoui's hard drive. In fact, it was because, you know, a high-level bureaucrat overruled somebody in the field. And yet, what was the consequence of that whole little episode was that Congress loosened the regulation, the restrictions of FISA on gathering information in criminal investigations.
And you think this Congress will impeach this man? You think the next Congress will impeach this man?
You know, I don't know the answer to it, and I only know that when you start these things, you have sort of hope and faith and belief. But there's other reasons for raising it. One of the things it does, whether it's censure or impeachment, is it changes the nature of the debate. The Republicans want the debate to be about security and, you know, and whatever their issues are. This changes the nature of the debate to saying this president is going beyond the law, this country is in danger. Even the fact that we're here tonight, or that we've done other panels, or that when we did the last C-SPAN event like this, we got hundreds of emails saying this is important, this is a way to change the debate. And I just wish that more Democrats and more even Republicans at this point would go along with understanding that that's the debate they ought to be having, not the debates the president has about the ports in Abu Dhabi or something.
This is a follow-up to that question. If so few people are willing to back Feingold's resolution of censure, how can we encourage our representatives to impeach?
Amy, I'd like to start off that discussion by going back to something I said in my initial comments. There have been resolutions from city councils, a number of them, maybe 2 dozen, 3 dozen, throughout the United States. It's the beginning of a movement. We're in the middle, we're at the beginning of a process, not at the middle or at the end. And if there is enough traction, and if there is enough groundswell, and if people speak to one another, speak to their neighbors and say, look at what, and people are disturbed by this. This is not a popular president. This is not a popular vice president. I believe that I read somewhere that Dick Cheney had an 18% approval rating. I don't think there's been any vice president that's been that low ever, including after Aaron Burr shot Alexander Hamilton. So, I think that the beginning, the discussion, the votes in city councils, the votes in wherever they are, PTA meetings or labor unions, these things are the beginning, and these can grow and will grow, and we've seen this happen in the past.
In fact, the CCR website actually has where you go to it for impeachment, ccr-ny.org, and if you go there, you'll see the list of representatives that have endorsed the Conyers resolution asking for an inquiry on impeachment. And it'll also list the congresspeople who haven't. And there's some 18 in New York who are Democrats who should, of which there's maybe a handful so far have. So one thing I would encourage everybody to do, at least at a minimum, is go to that website and do that.
And not only New York, all over the United States, people should be urging their congressmen to do that.
Yeah. And remember that Nixon won with an overwhelming electoral majority in 1972, and 2 years later he was gone. And there was a long and gradual process involving the criminal process and involving investigations. You had a barely Democratic Congress. 56%.
These questions go to the issue of spying. The administration, what are the administration's motives for warrantless surveillance legally relevant to building an impeachment case? Please elaborate on the concept of retroactive wiretaps. Has the names and other identifying information of those spied upon been collected? Is there any document filed to notify these people and the general public? And finally, I would like some practice advice. Can you tell me what has changed in my legal rights because of the laws recently passed? For example, do I have a right to refuse to be queried, frisked, or searched by the police or FBI without a warrant?
Well, I'm going to pass that last one maybe on to Bill. But in terms of motives, we tried to spell them out. The ones that would be relevant to impeachment, I think, are anything that would tend to subvert the division of powers in our government, would tend to diminish the role of either Congress or the judiciary. And we tried to spell out a little bit how some of the motives that we're attributing to the president that seem plausible to us, may be directed at that. So for instance, if the president is really sort of trying to advance his agenda to advance executive power in the abstract, then that obviously is a way of diminishing the power of Congress and the courts. If he's trying to carry out this sort of total information awareness, and he's trying to get around a specific funding statute of Congress that was designed to make sure that total information awareness didn't happen. And if he's trying to spy on attorneys and journalists who are trying to, sort of bring cases and write stories that are politically damaging to him, then he's subverting the fundamental democratic process that's the ultimate check on the president, the voting process. Retroactive warrants, basically what happens is the Attorney General has to notify the FISA court that he's putting in place an emergency warrant. They put it in place under FISA, and then within 72 hours they have to go to the FISA court with an application. Alberto Gonzalez has said they don't like doing this because there's a risk that if the FISA court turns down the application, then they have to notify the person who was a target. But obviously the risk of that happening is very small when you only have had 5 rejections in 26 years out of almost 20,000 applications. In terms of notification, you don't get any notice under FISA. And obviously you're not going to ever get any notice under something that's designed to get around FISA.
Would you read the last question again?
The question is some practical advice. Can you talk about what has changed in my legal rights because of the laws recently passed? Do I have a right to refuse to be queried, frisked, or searched by police or FBI without a warrant?
Absolutely, unless you're being arrested without a warrant, which there are certain. I'm not going to do a law lecture here on the Fourth Amendment and what's a reasonable stop, a search and seizure. There are times when people can be arrested without a warrant. At those times, you have to, you certainly have to be, it's lawful to stop and frisk you and search you and arrest you. You don't ever have to say anything to the FBI until you've spoken to a lawyer or at all. So if you don't want to talk to the FBI or to the police, don't do so, and demand a lawyer. I would not resist a stop and frisk if you've been arrested, and even if you haven't been arrested, they have a right to stop and frisk you if there's what's called reasonable suspicion. But without going through all of that, nobody ever has to say anything yet. And let's hope that no one ever will, unless they want to cooperate and work with the police. If you don't want to, if you demand a lawyer, insist on a lawyer, you're entitled to one still in the United States of America.
Here is another question. If we impeach Bush, do we effectively impeach his whole administration, especially Cheney? And then it says, when and how can we organize a demonstration to impeach them? What happens if Bush is impeached?
People always ask as the first question in these things, whether or not what we're advocating is President Cheney at the end of the day. I mean, I think obviously you could impeach him maybe in the same sort of joint trial for the very same offenses that we've talked about here. It's interesting that the Constitution actually makes the Chief Justice preside at the impeachment trial of the president because, back at the founding, the vice president was a person who was a runner-up, and so there would have been a conflict of interest if, as president of the Senate, he was presiding over the president's trial. But here, there's no problem with I think, having the Chief Justice preside over a trial of both of them.
Under federal law, only a federal prosecutor can obtain an indictment or file a criminal complaint. Why not pick a suitable state and have one or more citizens commence criminal proceedings under state law against Bush and company?
Under traditional legal theory, the federal officials are immune from state prosecutions or even federal criminal prosecutions, and then that's a no-starter. I think there's more hope in impeachment than there is in proceeding in terms of criminal complaints or indictments and prosecutions within the United States. Now, as was mentioned, there is a case in which Michael was very involved, in which a criminal complaint was sworn out in Germany against Donald Rumsfeld. And I think that the judgment of the legal systems of the world is something that American officials better start thinking about, because the more lawless they get, the more they have to fear the law, if not in this country, in others as well. I don't know, Michael, if you want to add to that.
Well, that case was filed about a year ago, finally went to the highest court. You can file your own criminal cases in Germany. They go to the courts eventually, and the court dismissed it about 2 days before Rumsfeld went to Germany. Rumsfeld said, I'm not going to Germany to the Munich Security Council unless this case is dismissed. And then they dismissed it. They dismissed it for the reasons that you normally have to file and proceed in your domestic remedy before you can go to an international, not an international court, but another country. And they said, we haven't exhausted really all of everything we could do in the United States. So we're going to file it again. Because now it looks, and it looked to them, the court said, like the U.S. was still going up the chain of command a little bit in terms of torture and things like that. We said no. I think it was, it's obvious the U.S. isn't investigating up the chain of command. They're going for lower-level officials. So we're going to go back to Germany in the fall, refile the case. The good thing is they took it seriously. It was certainly taken seriously in Europe. It's like everybody knows the emperor has no clothes, that the U.S. is deeply, deeply involved in torture. The administration is. Everybody except apparently a number of people in the United States.
I think just a little footnote, the president enjoys immunity from prosecution, criminal prosecution of any sort during his term. He can be indicted but not prosecuted. And so, if there is a criminal offense that the president conducts that is, maybe not a threat to the structure of government, but is so serious that it deserves immediate prosecution, then that also could be a grounds for impeachment.
This is a question about President Bush's signing statements. The two that have recently come out is signing statement with the USA Patriot Act, signing the Patriot Act, then signing a statement that says he is not bound to abide by the USA Patriot Act, and the other around the issue of torture, the McCain bill, the legislation that he passed New Year's Eve that he signed, and then signed a signing statement that said if he wouldn't have to abide by it if he didn't want to. This says President Bush is signing statements which are conceived effectively to let the president ignore legislation and deny Congress the opportunity to override a veto. This seems to exemplify subverting the constitutional government structure. Is anyone building a case or a suit on this? Is anyone in Congress worried about taking action? And then the question, is intent necessary? Is a finding of liability possible?
Well, the statement almost speaks for itself. I mean, it's clear that both of those signing statements, the one that I talked about with McCain that says he can ignore Congress as well as the courts, and the one that was mentioned on the Patriot Act, which is what the president actually did was interesting. He signed the Patriot Act, which of course he spent all this time getting through, and then that was done in a public ceremony, and after everybody else left the room, he signed the signing statement, where there was no press there. And what it does is it says that the minimal stuff Congress put in the Patriot Act, like you have to tell us the number of libraries you've gone to get the, what people are reading, or a number of sneak and peek searches you've done, the limited oversight in the Patriot Act. He says, I do not have to obey the law and report to Congress on how we are enforcing the Patriot Act. I don't have to do that because I'm protecting the national security of the United States. Both those statements, as well as other signing statements, are really, I think, as the writer of the question said, they really do subvert the Constitution, remove checks and balances, and are impeachable. And I don't know so far if any members of Congress have gone after those. I don't know if anybody else on the panel does, but.
Shouldn't one of the articles of Bush's impeachment be for dereliction of duty on 9/11? Bush mentioned 9/11 no less than 8 times in any early defense of extra-legal wiretapping.
Sorry, what was the last part?
Bush mentioned 9/11 no less than 8 times in an early defense of extra-legal wiretapping.
Right. As I said, I don't think any of his mentions of the 9/11 plot really hold a lot of water. Dereliction of duty. One of the things that the oath of office the president says is that he swears to uphold the laws of the United States and the Constitution and take care that the laws are faithfully executed. And I think in all of the situations we've described here, there are certainly instances where the president hasn't tried to accurately sort of carry out the intent of Congress in various statutes, whether they relate to torture or wiretapping or anything else that we've talked about today.
I think another point about this is that, leaving aside the question of dereliction of duty, and maybe that's another basis for impeachment, but the theme that we've been at least addressing tonight, which is the ways since 9/11 that he has basically engaged in a pattern of illegal activity, from lying to get us into a war to wiretapping to all the rest of it. These have been 9/11 has been a fortunate event in many ways for these policies, in the sense that the administration has used that opportunity to engage in a vast destruction of civil rights and civil liberties in the United States. And I believe that if the terrorists who flew planes into the World Trade Center on 9/11 were out to destroy American democracy, their strongest ally was in the White House at the time.
This is for any panelist. Seriously, do you believe any single thing, embarrassment, lawsuit, impeachment, civil conviction after office, will ever happen to George W. Bush?
Well, I'm not willing to, at this point, as I said, it's early on. The polls were surprisingly strong on impeachment on 2 issues, lying about the war in Iraq and national security wiretapping, reaching as high as 50%. And you do have an election coming up. You have to put some spine into the Democrats who hopefully will be elected. But at this point, I'm an optimist. I don't think I've ever in my 35 years of being a human rights lawyer ever seen a set of conduct like this, so subversive of our democracy. So I'm an optimist about it.
I think it's unlikely that the Democrats are going to gain control of the House of Representatives in this next election, but I think it's distinctly possible. If they do, I might point out that the ranking Democrat on the House Judiciary Committee, which is responsible for initiating impeachment proceedings, is Mr. Conyers, who has proposed the resolution. So, if for no other reason, it's a good reason to vote for Democrats this next election.
Yeah, and once it starts, you don't have any idea where it will lead. Who expected those tapes to exist? Who expected John Dean to plead guilty?
Deficit spending and attacks on the environment are destroying our security and that of our children's future. Is this also grounds for impeachment?
Sure. I mean, it is. I mean, that's not, and of course it's, you know, I mean, the country, there is a relationship between the loss of civil liberties, including the loss of First Amendment rights to engage in protest, which we've seen happen, and the issues that are being protested, the destruction of the environment, the loss of jobs, the danger to non-citizens, immigrants in the United States today, of being arrested and detained for long periods of time. All of these things come together, and I believe that all of us, environmentalists, labor unionists, civil libertarians, all of us have a passionate interest in this question, getting rid of these scoundrels.
Another person has asked the question tonight, right now, what are 2 or 3 effective steps we can each take individually or collectively to impeach and remove Bush and key cronies from office? And the second part of the question, what are the forces in play that would facilitate impeachment of Clinton for largely personal indiscretions, yet leave in power a horrific Bush and his administration for much more egregious acts?
I mean, the first and most obvious one is the one I mentioned, which is that you should support your representatives going with the Conyers motion for an inquiry on impeachment. There's 33 people have supported that inquiry. Every representative ought to support the inquiry. It's not even asking ultimately right now for impeachment. It's saying an inquiry on all of these issues that we've raised. I think that would be a huge boost and would make this administration very, very nervous. And I should say the same around the Senate and Senator Feingold. The poor guy is out there with 2 other senators supporting him. All of our senators ought to be put on the rug and say, support this inquiry about censure. Do it. I mean, they just got to do it. I mean, I would just, you know, that's a minimum. To walk away and not do that, you know, would not be really doing your civic duty at this point.
And there's a grassroots movement building in the same way there was around opposition to the Patriot Act, where local governments, you know, city councils across the U.S. are sponsoring, you know, bills that you know, voice opposition to various practices here and support for impeachment. So that's a way to get the ball rolling. It's a long process. It was with Nixon also.
I've got to tell you, I was in, I've mentioned this several times already, but I was in upstate New York, and there was a resolution in the city council in Plattsburgh, New York, which is not a radical community by any means. It's a community dominated, among other things, by the correctional profession. And it barely lost. It's being raised again and again, and I think that it's going to pass in Plattsburgh, New York, and it's going to pass in similar conservative communities throughout the United States of America. And I think our hope is, if someone wants to think about organizing, is to join not just with people who are liberals or people who are Democrats or people who voted against George W. Bush, but with honest conservatives all over this country who know now that they've been betrayed by this man.
People are dying every day. What can we do now to motivate Bush to resign immediately, as did Nixon?
Well, I mean, you know, one of the things that I think is happening all over the country are demonstrations every day in every city and every town. And it's a huge range of conduct, from the people who turned their backs on Gonzales at Georgetown when he gave a speech. This is the man, of course, who wrote the torture memos. To wearing, I think that, you know, wearing, who is it that, maybe you remember, one of your guests, wore hoods in Congress one day, McGovern. They put on jumpsuits and they wore them through the halls of Congress. Anyway, there's a whole range of conduct that people ought to be joining in all across the country. Demonstrations, turning their backs on these people, I mean, really letting people know that you care. I would like to see a college movement start of building cages in colleges to represent Guantanamo. I mean, all kinds of things that represent each of these kinds of articles of impeachment that people have to get active on. Sure, it's important to call your senator and your representative, but it's more important, really, I think, to get into the streets right now and really engage in incredibly big, vigorous protests.
Well, on that note, I want to thank you all for coming and give our panelists 1 minute each to wrap up on what you think is the most important issue for people to take away from this session. Bill Goodman.
One of my own heroes as I've grown up and throughout my life, I've had many, but one of them was Joe Hill, a famous trade unionist, who, after being framed on a murder charge, was executed. And when he died, he said, "Don't mourn for me, organize." And that's what we have to start doing. And that's been, I think, the theme on which we've ended this discussion tonight. So I urge all of you, and regardless of, as I said, of your political orientation or how you voted in the last election, to think about the fact that for 300 years we have had a system of democracy which, with all of its weaknesses and flaws, has worked in many ways and has provided all of us with individual rights. It's now in grave danger. Organize, bring together people that you know, and let's put an end to this through impeachment and in any other way we can.
Yeah, just to sort of pick up on that, I think one of the great advantages of starting the debate about impeachment, of potentially having hearings or just getting it out there in terms of public discussion, is that it changes the tenor of a lot of the facts that we've talked about here, from war on terror and national security to criminal behavior. And and just in that regard, I think one thing that's important that we haven't really emphasized either about the wiretapping or a lot of this other stuff is that none of it really furthers national security. Just in terms of the wiretapping, there's the obvious point that this information from the NSA, if it turns out to have been gathered in violation of the Fourth Amendment, could conceivably contaminate any number of other sort of warrants that are out there. The FBI may take information from the NSA program, get a legitimate search warrant, use that to underlie a prosecution of a drug dealer overseas or something like that. Hundreds and hundreds of prosecutions like that may be put at risk by the administration's recklessness in using this sort of program, and yet they're out there arguing that it's something that furthers the national security. We've got to change that debate. Similarly, anytime you've got broad brush sort of profiling methods of gathering information or of arresting people, as with the Turkmen detainees who were swept up after 9/11, it usually turns out that nothing valuable results from it except a huge waste of law enforcement resources. So the 1,200 special interest detainees, none of them were ever charged with any link to terrorism. Similarly, the New York Times reported the day we filed our suit that the NSA program had generated thousands of dead leads and wasted huge amounts of FBI resources and resources of other law enforcement agencies. I think one of the things we've got to do is change the discourse from this is all being done in the interest of national security to sort of revealing that in fact it's counterproductive, that it makes us less free and less safe, and then people can start sort of reckoning with the illegality of it.
Shana Cadidel. Michael Ratner.
A couple of things. One is you should definitely go to the Center for Constitutional Rights website. At that website, you can order this book, Articles of Impeachment Against George W. Bush. I mean, it really puts it all in one place. One of the real strengths, I think, of impeachment is that it consolidates in one place all of these issues that a lot of different people are working on. So that even if we win a Guantanamo case, then there's going to pop up a Bagram, or then they're going to try and do a Detainee Treatment Act. What impeachment does, and what this book sort of lays out, is making these all of a piece. So go to that website. It's ccr-ny.org. The last thing I would say is, look, this administration, I've said for at least a year or two now, is really weakened. It's on the run. It's self-destructing. But it's really a time and an opportunity for us to take advantage of that. It's not going to happen unless we really push it over. So we've said how to do it here, but we have to all get active and really push it out of office. Thanks.
Maria LaHood.
I would say share people's stories. I think the secrecy that the Bush administration has cloaked the detention practices, the torture practices in, make it nearly impossible for people to become outraged. But I think if you know one face, if you know one story of someone who was tortured and indefinitely detained because of President Bush, and you can share that story with people and you can share that person's face, and you can hear how that person was a boy when he was abducted for no reason or because somebody paid money, then I think people, bit by bit, will be able to see what Bush has done. And then hopefully that will lead to impeachment. Thanks.
Want to thank the Culture Project for providing the space for this event. And encourage you all to watch or listen to Democracy Now! And support independent media in all its forms, whether it's public access TV or Pacifica Radio, public radio or public television, independent satellite TV like Link TV and Free Speech TV. If we are going to hear what people have to say that is outside of the range of the corporate media, whether you agree or not, that's what makes this country safer, and we have to protect all of those independent media spaces. So find out where you can watch or listen to Democracy Now! At democracynow.org, and continue to have these discussions. Encourage these debates wherever you go. It matters here in this country, and it matters for people all over the world. Thanks very much.